all other persons who have joined our meeting. This meeting is now being live streamed. And then secondly, I'm just going to give a quick opportunity to the PLO of the Minister, Joe Khatla, to introduce the members of the NDOH who are present. And then Ms. Isaac, if you maybe can just go back a little bit and just start in the beginning for the sake of the live streaming. Maybe just quickly recapture the beginning of your presentation. Thank you. Mr. Khatla.
Good morning, Honorable Chair, Honorable Members. From the National Department of Health, Honorable Chair, we've got the team that has usually been involved in this process, led by Professor Nicholas Crisp, Dr. Kwena Tulare, Mr. Moremi Nkosi, and there are indeed other senior members of the National Department of Health and the admin staff. Thank you very much, Chair.
Thank you very much. Back to you, Ms. Isaac.
Thank you, Chairperson. Yes, Chair, as just to recap, our office at Parliament's Legal Services was requested to comment on the National Health Insurance Bill, and I'm going to go through the certain aspects of the bill, the themed areas, but chronologically. So the first issue that I deal with is the Competition Act. So Clause 3.5 of the NHI Bill provides that the Competition Act is not applicable to any transaction concluded in terms of the Act. Clause 58 of the NHI Bill also seeks to amend the Competition Act by inserting a new provision in Clause 3 to exempt the NHI fund from its application. Section 2171 of the Constitution requires that when procurement for goods and services is undertaken by an organ of state or any institution identified in national legislation, it must be done in accordance with a system which is fair, equitable, transparent, competitive, and cost-effective. The Competition Act seeks to prevent and prosecute anti-competitive behavior and allows the Competition Commission to investigate such behavior at the pains of a possible fine. The wording of Clause 3.5 in the NHI Bill is broad in that it excludes all transactions concluded in terms of the NHI Bill from the application of the Competition Act. This exclusion will not only apply to the NHI fund, but also to all parties who contract with the NHI fund, including service providers and suppliers. This may create an opportunity for anti-competitive behavior. Further, the exclusion will not be in keeping with the constitutional requirements of Section 217 of the Constitution to ensure fair, equitable, transparent, competitive, and cost-effective procurement. The Competition Act will provide the NHI fund with important safeguards from anti-competitive conduct and will ultimately protect the fund and the public. I therefore agree with the proposal to limit the exclusion in Clause 3.5 to only the NHI fund. Just to reiterate again, a proposal was made during the committee's deliberations to limit this, and the committee should consider that. I'm now moving on to the theme of access to healthcare, and I'm just going to explain what this right entails. So in terms of Section 27 of the Constitution, it provides for healthcare, food, and social security. Of relevance for this presentation is Section 27(1), which says everyone has the right to have access to healthcare services, including reproductive healthcare. 27(2) states the state must take reasonable legislative and other measures within its available resources to achieve the progressive realization of each of these rights. 27(3) says no one may be refused emergency medical treatment. Now, coming back to the NHI Bill, healthcare services is defined in the bill as follows. healthcare services in subclause A says healthcare services, including reproductive healthcare and emergency medical treatment contemplated in section 27 of the Constitution. B, basic nutrition and basic healthcare services contemplated in section 28(1)(c) of the Constitution. C, medical treatment contemplated in section 35(2)(e) of the Constitution. And D, where applicable, provincial, district, and municipal healthcare services. The NHI bill defines emergency medical services to mean services provided by any private or public entity, dedicated staff and equipped to offer pre-hospital and acute medical treatment and transport of the ill or injured. So under this heading of access to healthcare, the first topic that I will deal with is asylum seekers. In terms of the NHI bill, asylum seekers are entitled to emergency medical treatment and services of notifiable conditions of public health concern. And this is in clause 4.2 of the bill. Refugees are entitled to the same healthcare services as South African citizens. So in terms of the NHI bill, asylum seekers has the meaning ascribed to in terms of section 1 of the Refugees Act. And the Refugees Act defines an asylum seeker to mean a person who is seeking recognition as a refugee in the Republic. In contrast, the Refugees Act defines a refugee to mean a person who has been granted asylum in the Republic. Now, with regard to the current, with regard to section 27 of the Refugees Act, which provides for protection and general rights of asylum seekers, this is what that particular section says. And specifically, I point the committee to subclause D, which says, an asylum seeker is entitled to D, the rights contained in the Constitution of the Republic of South Africa in 1996, in as so far as those rights apply to an asylum seeker. Now I'm going to just point out the current entitlements of asylum seekers in terms of the National Health Act. Basically, this is the current regime in our country. Section 4.3 of the National Health Act provides for eligibility for free health services in public health establishments as follows. And this subsection says, subject to any condition prescribed by the minister, the state and clinics and community health centers funded by the state must provide A, pregnant and lactating women and children below the age of 6 who are not members or beneficiaries of medical aid schemes with free health services. B, all persons except members of medical aid schemes and their dependents and persons receiving compensation for compensable occupational diseases with free primary health care services. And C, women subject to the Choice of Termination of Pregnancy Act 1996, free termination of pregnancy services. So an asylum seeker is a person who has made an application for refugee status. An asylum seeker is not in the country illegally pending the outcome of that application. Asylum seekers enjoy various constitutional rights and protection, including rights afforded to everyone in terms of section 27 of the Constitution. Currently, asylum seekers, with or without documentation, may receive access to primary healthcare services and antiretroviral therapy subject to a means test. And this is in terms of the Department of Health's own directive. All pregnant and breastfeeding women, including asylum seekers and children below the age of 6, who are not members or beneficiaries of medical aid schemes, may access free healthcare services. Public healthcare services are provided to South African citizens in the same manner. Basically meaning that if you are subjected to a means test to access these services. moving on to paragraph 15, in terms of the NHI bill, an asylum seeker will no longer enjoy access to primary healthcare services, reproductive healthcare, and antiretroviral therapy. An asylum seeker who does not have financial means will have no alternative manner to access healthcare services. Section 27(2) of the Constitution places the duty on the state to take reasonable legislative and other measures within available resources to achieve progressive realization of each right, to achieve progressive realization of each of these rights for everyone. The NHI bill will deprive asylum seekers of existing constitutional entitlements to access to healthcare. This will amount to a retrogressive measure and will mean that the state will be impairing existing rights. This cannot be done without a compelling justification for imposing these measures. The courts have held that a person cannot be deprived of existing access without this being justified in terms of Section 36 of the Constitution. The Department of Health has not provided any justification as to why asylum seekers will no longer be allowed the access to the level of healthcare service which they currently have access to. The next issue that I'm going to deal with is children. In terms of clause 4.3 of the bill, all children, including children of asylum seekers or illegal migrants, are entitled to basic healthcare services as provided for in section 28(1)(c) of the Constitution. Basic healthcare services is not defined in the NHI bill. However, basic healthcare services is one aspect of services under healthcare services. I had earlier shown the committee the definition, and you would have seen basic healthcare is just one component of healthcare services. Section 4.3d of the National Healthcare Act provides, and I've stated this earlier, subject to any condition prescribed by the minister, the state and clinics and community health centers funded by the state must provide pregnant and lactating women and children below the age of 6 years who are not members or beneficiaries of medical schemes with free health services. Currently, all children enjoy free primary healthcare and children under 6 enjoy free healthcare services. Children in this context includes children of asylum seekers or illegal migrants. According to section 28(1)(c) of the Constitution, every child has the right to basic healthcare services. Section 28(3) requires a child's best interests are paramount importance in every matter concerning a child. It is unclear what basic healthcare services entails. However, in terms of the NHI bill, it is defined as one aspect of the more comprehensive term healthcare services. The term basic healthcare services should be defined or clarified. In terms of the Constitution, children of asylum seekers and illegal migrants must continue to enjoy the same level of access to healthcare services as currently provided to them. And just to make clear, the reason why children of asylum seekers and illegal migrants are specifically addressed is that because children of other users will be entitled to the full level of services that their parents are entitled to. So if you're a South African citizen, your children are entitled to the full level of care. But what is not clear is with regard to the children of asylum seekers and illegal migrants, if they're only entitled to basic healthcare services, what exactly does that entail? The next issue that I will deal with is registration, and registration as it relates to accessing healthcare. So with regard to this matter, in terms of clause 4, subclause 4 of the bill, it states, any person seeking healthcare services from an accredited healthcare service provider or health establishment must be registered as a user of the fund as provided for in section 5 and must present proof of such registration to the health care service provider or health establishment in order to secure the healthcare service benefits to which he or she is entitled. In terms of clause 5.1 of the bill, a person who is eligible to receive healthcare services in accordance with section 4 must register as a user at an accredited healthcare service provider or health establishment. In terms of clause 5.8 of the bill, a user seeking healthcare services purchased for his or her benefit by the fund from an accredited healthcare service provider or health establishment must present proof of registration to the healthcare service provider or health establishment when seeking those healthcare services. In terms of clause 6.18, it states, without derogating from any other right or entitlement granted under this act or under any other law, a user of healthcare services purchased by the fund is entitled within the state's available and appropriate resources to receive necessary quality healthcare services free at the point of care from an accredited healthcare service provider or health establishment upon proof of registration with the fund. The point that I want to make is that not every eligible user will register with the NHI fund especially during the initial rollout of the NHI. There may be individuals, especially vulnerable persons, who do not have the required documentation for registration, such as having proof of habitual place of residence. In terms of the wording of the NHI bill, access to healthcare services, and this includes emergency medical treatment, is dependent on prior registration with the fund, and proof of registration is required to access healthcare services. In terms of the Constitution, no one may be refused emergency medical treatment. Therefore, registration cannot act as a barrier to access emergency medical care, emergency healthcare services. Further, the registration required must take into consideration that some people, especially vulnerable persons, may not have access to the required documents, and the NHI bill must seek to accommodate them. The next issue that I deal with regard to registration is what I term vulnerable people. In terms of clause 5.1, a person who is eligible to receive healthcare services in accordance with section 4 must register as the user of the fund as an accredited healthcare service provider or health establishment. Now, clause 5.2 and clause 5.4 set out the process in terms of which children are registered with the NHI fund. The NHI bill does not set out a process to register other vulnerable people who may be unable to register as NHI users. These include aged persons and mentally challenged persons. The committee should consider making a provision for the registration of other vulnerable groups. So just to emphasize, these are people who may not be able to register, but there isn't an empowering provision that basically says that this is how they could register with the fund if they're unable to do so by their own means. The next issue that I'm dealing with is the rights of users, and the NHI bill sets out various rights of users. In terms of clause 6.1c provides for the rights of users to access information about their personal information. The bill states that a user of the fund is entitled to access any information or records relating to his or her kept by the fund as provided for in the Promotion of Access to Information Act in order to exercise or protect his or her rights. However, in terms of section 32(1)(a) of the Promotion of Access to Information Act 2000, it states everyone has a right of access to any information held by the state. The wording of the bill seems to place a qualification on a person's ability to access their health records. A person has a right to access their health records for any reason. The next two comments are more technical drafting issues. So in clause 6K and 6O, it provides that without derogating from any other right or entitlement granted under this act or under any other law, a user of healthcare services purchased by the fund is entitled, and we have this phrase that says within the state's available and appropriate resources And in K, it says to lodge an appeal against the decision of the fund in accordance with Section 43. And O says to purchase healthcare services that are not covered by the fund through a complementary voluntary medical scheme registered in terms of the Medical Schemes Act, or any other private health insurance scheme or other out-of-pocket payment, as the case may be. In respect to clause 6K, the right to lodge an appeal cannot be dependent on the state's available resources. There is a difference between lodging an appeal and an appeal not being granted because of the state's resource constraint. In respect of clause 6O, the purchase of complementary healthcare is not dependent on the state's available resources. The committee should consider that the wording of these clauses should be amended. The next issue that I'm going to deal with is referral pathways. Clause 7 of the bill provides for healthcare service coverage. Clause 7(2)(d) requires a user of the NHI fund to first access healthcare at the primary level. A user is further required to adhere to the referral pathways for health services. Clause 7(2)(d) Roman 3 provides as follows. Subject to clause 4, a user is not entitled to healthcare services purchased by the fund if he or she fails to adhere to prescribed referral pathways. Clause 8(b) provides that a person or user, as the case may be, must pay for healthcare services rendered directly through a voluntary medical insurance scheme or through any other private insurance scheme, fails to comply with referral pathways prescribed by the healthcare service provider or health establishment. The wording of clause 7(2)(d) Roman 3 and clause 8(b) reads as an absolute bar on a user who has failed to follow the referral pathways from accessing healthcare paid for by the NHI. So it is unclear what becomes of a user who requires treatment but may not access treatment as stated above. The clause also requires an absolute and unwavering adherence to referral pathways by both the provider and patient, and no criteria is provided that allows for any flexibility for when a failure to follow a referral pathway is reasonable. During the deliberations, the ANC proposed that clause 8(b) be deleted to prevent people from bypassing the referral process and seeking to pay for medical services. However, in light of the point I made above, a person who has failed to adhere to the referral pathways, whether they are able to pay or not pay, still will have no access to healthcare in terms of clause 7(2)(d) Roman 3, as the bill does not allow for any deviation from referral pathway. Clause 7(4)(a) states, the next issue that I'm going to deal with is cost coverage. Clause 7(4)(a) states that treatment must not be funded if a healthcare service provider demonstrates that no medical necessity exists for the healthcare service provider in question, healthcare service in question. Clause 8(c) states that a person or user, as the case may be, must pay for healthcare services rendered directly through voluntary medical insurance schemes or through any other private insurance scheme if the person or user seeks services that are not deemed medically necessary by the Benefits Advisory Committee. It's been suggested in some of the submissions that the wording of clause 8(c) should be amended to refer to the healthcare service provider rather than the Benefits Advisory Committee to ensure consistency. The issue is as to who makes the decision as to what is medically necessary and what happens to a person who is unable to access healthcare through the NHI. Clause 8(2) only provides a person or user Clause 8.2 only allows a person or user to pay for healthcare services through either a voluntary medical insurance or other private insurance. The clause does not provide for the possibility of out-of-pocket payment as referred to in clause 6.0. So this may have been an omission where the bill does speak about out-of-pocket payments, but this particular clause does not reflect that. The next issue that I'm dealing with is the role of provinces. And obviously this was one of the issues that had a lot of debate around it. So some submissions have expressed the view that the NHI bill reduces the role that provinces play in respect of health services. Health services is listed as a functional area of concurrent national and provincial legislative competence in Schedule 4 of the Constitution. Section 44(1)(a) Roman 2 and Section 104(1)(b) Roman 1 of the Constitution vest concurrent legislative authority in Parliament and provincial legislatures over the area of health services. This means that both the national legislature and the provincial legislatures can pass laws relating to health services. The Constitution does not determine how these concurrent powers must be delineated between national government and provinces. However, Clause 146 of the Constitution applies to conflicts between national legislation and provincial legislation falling within the functional areas listed in Schedule 4. If there is conflict between national legislation and provincial legislation, national legislation that applies uniformly with regard to the country as a whole prevails over provincial legislation if any of the conditions listed in the Constitution are met. That would be an instance where there is two competing pieces of legislation and there needs to be an interpretation as to whether the national legislation overrides the provincial legislation. However, in this instance, the national legislation is the act that defines this particular area. So with regard to legislation enacted by Parliament, legislation enacted by Parliament that deals with health services must follow the process set out in terms of Section 76 of the Constitution. A Section 76 bill that is introduced in the Assembly and passed by it has, and then referred to the National Council of Provinces to consider it, is then passed by it and then referred to the National Council of Provinces for its consideration. In terms of Clause 76(1)(a), the NCOP must pass the bill, pass an amended bill, or reject the bill. In terms of Section 76(1)(d), if the NCOP rejects the bill, or if the Assembly refuses to pass the bill as amended by the NCOP, the bill or amended bill must be deferred to a mediation committee that may pass the NA version of the bill, the NCOP version of the bill, or another bill. In terms of 76(1)(e), if the mediation committee is unable to agree within 30 days of the bill's referral to it, the bill lapses unless the Assembly again passes the bill, but with the supporting vote of at least 2/3 of its members. Now, the above indicates that in terms of Section 76 bills, such as the one dealing with health services, provinces have a greater say in the legislative process. And the point that is trying to be made that provinces are going to be able to deliberate and decide about the provisions of NHI. The next paragraph is paragraph 38. The National Health Act provides a framework for structured uniform health systems within the Republic, taking into account the obligations imposed by the Constitution and any laws on the national, provincial, and local government with regard to health services, and to provide for matters connected therewith. The NHI bill seeks to change some of the functions conferred on provinces in terms of the National Health Act. The NHI bill seeks to amend Section 25(2) of the National Health Act to remove certain functions currently performed by the head of the Provincial Department of Health, and some functions of the provincial heads will be prescribed by the Minister in regulation. The NHI bill also seeks to amend Section 27 of the National Health Act to change the functions of Provincial Health Council. There is no specific constitutional provision that gives provinces specific functions in respect of health services. The different functions and roles of national and provincial departments are set out in legislation, namely the National Health Act. As the NHI bill is a Section 76 bill, province will have a greater say in deciding on its functions and roles and may reject the proposed changes made in terms of the NHI bill. However, with regard to specific amendments in Section 25(2) of the National Health Act, that is specifically would say the minister may prescribe the functions of the provincial head. It must be pointed out that the health functions of the provincial head is a substantive matter and should not be delegated to the minister to determine in terms of regulation. The next issue is in clause 7.2f Roman 1 of the bill provides that in order to ensure the seamless provision of healthcare services at the hospital level, the minister by regulations designates central hospitals as national government components in accordance with Section 7.5 of the Public Service Act 1994. In terms of Section 7.5 of the Public Service Act, the president is the authority that may designate a national component. The wording of clause 7.2f1 of the NHI bill must be clarified, as the president has the power to designate a national government component and not the minister. That is a matter that the committee must consider because it is not consistent with the Public Service Act. Some of the comments received state that the designation of central hospitals as national government components will remove the authority of provinces that may be unconstitutional. However, the powers of the minister in respect to central hospitals are currently set out in Section 41 of the National Health Act. The NHI bill will amend the statutory powers of provinces as set out in the National Health Act, and it's not a constitutional power that they are amending. The next issue that I deal with is medical schemes. And this is another area that received a lot of comments. Clause 6.0 provides that the user may, in certain instances, purchase healthcare services that are not covered by their fund through a complementary medical scheme. In terms of clause 8.2, a person or user is required to pay for healthcare services as set out below. So in terms of this clause, a person or user, as the case may be, must pay for healthcare services rendered directly through a voluntary medical insurance or through any other private insurance scheme if the person or user, A, is not entitled to healthcare services purchased by the fund in terms of the provisions of this Act, B, fails to comply with referral pathways prescribed by the healthcare service provider or health establishment, C, seeks services that are not deemed medically necessary by the Benefits Advisory Committee, and D, seeks treatment that is not included in the formulary. Clause 33 of the NHI bill provides for the role of medical schemes as follows. Once national health insurance has been fully implemented as determined by the minister through regulations in the Gazette, medical schemes may only offer complementary cover to services not reimbursed by the fund. The NHI bill does not provide much detail on how medical schemes will operate once the NHI bill is enacted. Further, it is not clear how current medical scheme users will access healthcare services during the phased implementation of the NHI bill. This creates legal uncertainty. The NHI is funded by a mandatory prepayment. It is not clear if medical scheme users will be required to make the mandatory prepayment while still paying their medical scheme contribution, while NHI is not fully implemented. Further, as the full benefits available on NHI have not been determined, it is unclear to what extent it will affect the rights of those currently receiving treatment via medical schemes. Additionally, the role of medical schemes will be fundamentally altered once the NHI is fully implemented. medical schemes will in future only offer complimentary cover for services not reimbursed by NHI fund. Some submitters that have argued that this violates the right to access to healthcare and freedom of association. The Constitution requires that the state take reasonable legislative and other measures within its available resources to achieve the progressive realization of rights, including in respect of access to healthcare services. If medical scheme users suffer a reduction in access to healthcare services as a result of the full implementation of the NHI, this will give rise to a constitutional challenge based on the violation of Section 27(1) of the Constitution, that is, their right to access to healthcare. The next issue that I'm dealing with is the governance of the fund. And again, this is an area that we received a lot of comments on. The minister has extensive powers in respect of the NHI fund and is involved in all decision-making of the NHI fund. Clause 10 sets out the functions of the fund. In terms of clause 31B, the minister is responsible for governance and stewardship of the fund in terms of the provisions of the Act. The level of accountability and the independence of the NHI fund and board are policy considerations. However, if the minister is involved in all key areas of the fund, the question that arises is how would she or he, as the executive authority, exercise oversight over the board, the accounting authority. Clause 11 provides for the powers of the fund. Clause 11(1)(8) states that in order to achieve the purpose of the Act and perform the functions outlined in Section 10, the fund may investigate complaints against the fund, healthcare service providers, health establishments, or suppliers. This clause requires the fund to investigate itself. While it is necessary to have an internal investigative function, the NHI bill should stipulate that this structure must carry out its investigative function independently and without interference of the minister, the board, and third parties. In terms of clause 12, a board that is accountable to the minister is hereby established to govern fund in accordance with the provision of the Public Finance Management Act. Clause 13 provides for the constitution and composition of the board. The minister appoints the board of the fund and the chairperson of the fund. In terms of clause 3.2, the minister must issue a call for public nominations for people to serve on the board in the Government Gazette. In terms of clause 3(3), an ad hoc advisory panel appointed by the minister must conduct public interviews of short-listed candidates and forward their recommendations to the minister for approval. The bill does not indicate what criteria the minister will use to appoint the ad hoc advisory panel. Further, the bill does not indicate who will shortlist the candidates that will be interviewed by the ad hoc advisory panel. Considering the importance of the NHI fund and board, a greater degree of public involvement and transparency may create greater public confidence in the board. Many submitters have suggested that the board be selected in terms of a parliamentary process. There are statutory boards that are selected in terms of a process in the National Assembly. These are the boards of the Media Development and Diversity Agency and the South African Broadcasting Corporation. However, the process by which the board is appointed is a policy decision for the committee to make. It's a choice that is within the purview of the committee and Parliament. In terms of clause 10.4, the minister must publish the names of the board in the Gazette when they are appointed. However, with regard to the CEO, the minister is also required to inform Parliament of the appointment in terms of clause 19.3. The committee may consider including this requirement in respect of the board. That's just an issue of consistency and also having Parliament be alerted in the same manner that they are alerted about the CEO. The committee may consider including in clause 3.5 a requirement that a person appointed to the board may not have a criminal record and not be unrehabilitated insolvent. Further, the committee may consider including a provision in clause 13 that the board must broadly reflect the demographics of South Africa in terms of race, gender, age, and disability. This is to ensure that the board broadly represents the South African population. This particular in paragraph 45 is a technical issue. Clause 13.5b states that the board members must have appropriate technical expertise, skills, and knowledge or experience in healthcare service, financing, health economics, public health planning, monitoring and evaluation, law, actuarial science, information technology, and communication. The use of the conjunction "and" is incorrect, as it means that a single board member must possess knowledge in all the listed areas. The word "and" must be changed to "or" to indicate that the board member is required to have knowledge in at least one of the fields. With regard to clause 13.8, a board member should only be removed in terms of clause 13.8 after a proper process is followed. This clause should have a similar stipulation provided for in clause 19, which does provide for the process of removal. In clause 13.9a states, subject to paragraph B, the minister may dissolve the board on however, nothing in clause 13.9a is dependent on the provisions of clause 13.9b, and the phrase subject to paragraph B should be deleted. This again is more of a technical drafting issue, just to ensure that the clauses read correctly. Clause 13.7 provides for the resignation of a board member. Clause 13.8 provides for the removal of a board member. In both these instances, a vacancy is created on the board. There may be circumstances where multiple board members resign or are removed from the board. This will create more than one vacancy that may affect the effective functioning of the board. The committee may consider including a provision to fill vacancy on the board for the remainder of the board's term. In terms of clause 13.9a, the minister may dissolve the board on good cause shown only after following a process. However, dissolving the board on good cause is very broad and is entirely at the discretion of the minister. And this decision may be susceptible to political consideration. Committee should consider including specific criteria as to when the minister may dissolve the board. This will act as an accountability check on the minister's power to dissolve the board. Clause 15.3 requires that the board advise the minister on various matters, including the management and administration of the fund, including operational, financial, and administrative policies and practices. The powers of the board are mainly advisory in nature. The bill does not stipulate that the board is responsible for the control and management of the fund. It is unclear what leadership and strategic role is played by the board. There should be a clear separation between governance and operational matters. The board must advise the minister on governance matters and the CEO on operational matters. In terms of clause 15.3.5, the board must advise the minister on collective bargaining. In clause 15.2e, the board must advise the minister on terms and conditions of employment of fund employees. In terms of clause 20.2b, the CEO is responsible for organizing and control of the staff of the fund. Collective bargaining and employment terms and conditions are matters that are operational in nature and are functions conducted by the CEO. It is therefore unclear how the advice on these matters will assist the minister. The board should be advising the CEO on these issues. The bill does not set out how the board will function in terms of the quorum required to make binding decisions and whether the chairperson will have a deciding vote in situations where deadlock arises. Clause 16 provides for conduct and disclosure of interest. Clause 16.3 precludes a board member from participating in a meeting on a matter in which she or he may have a financial interest. Financial interest is defined to mean financial interest means a direct financial material interest of a monetary nature or to which a monetary value may be attributed. The committee should consider extending this to include an indirect financial interest. Further, the financial interest should not be confined to monetary interest, as this may enable persons to circumvent this section of the NHI bill. We now move on to the Chief Executive Officer. Clause 19 provides for the appointment of the Chief Executive Officer. Clause 19(2)(b) states that the board must forward their recommendations to the Minister for approval by Cabinet. The word recommendations is in plural and should be the recommendation. The board should recommend the best candidate for the job, as it is the body that is conducting interviews. If more than one person is recommended, there will be no basis for the cabinet to decide between the two candidates. Clause 19 does not set out in Clause 19 also does not set out in detail the selection criteria for the CEO. It is important that the person appointed is appropriate for the role. In paragraph 65, we deal with the removal of the CEO. The removal of the CEO in clause 95 must occur after a fair process. The committee may consider amending clause 95 to read: the board may recommend to the minister the removal of the chief executive officer after a fair process if the person and the criteria will follow as to grounds removal. In terms of clause 95C, the CEO may be removed if he or he becomes unable to continue or perform the functions of her or his role for any other reason. This provision is too broad and subjective. The grounds of inability to continue to perform a job should be limited to poor work performance or ill health. Clause 23 empowers the CEO, subject to the discretion of the board, to set up various units in the NHI fund. Clause 22E should be aligned with subsection 23I to ensure that the units do not have similar functions. By way of example, the investigative unit in clause 20E seems to be a duplication of the risk and fraud prevention investigation unit in clause 20, that should be clause 23, Roman I. There is a unit established in terms of clause 23C for provider payment mechanisms and rates, and in clause 3F for provider payments. The bill therefore needs to provide a clear role definition for units to be established by the CEO to avoid duplication and a waste of resources. The next issue that I will deal with is committees established in terms of the NHI bill. Clause 23 provides for the establishment of committees of the board. The clause is open-ended and does not determine the purpose, function, and membership of these committees. Clause 24 enables the board to establish a number of technical committees. The requirements for all these committees should be aligned across the NHI bill and may include, as applicable, the qualification requirements for appointment, the number of persons comprising the committee, appointment procedure, terms of appointment, fitness of the person as that may be appointed, procedure for removal of members, disqualification criteria for vacancies, remuneration and the minimum number of meetings, and provisions for conflict of interest. The next issue is advisory committees established by the minister. Clause 25 provides for the establishment of the Advisory Benefits Committee. This clause does not indicate the process by which the BAC members will be appointed. Clause 25(3)(b) provides that a person appointed in terms of subsection 2 ceases to be a member of the committee when he or she is no longer a member of the institution that nominated him or her when he resigned. This clause does not provide for a nomination process, and I am in agreement with the suggestion by the department to delete the underlying words. Clause 26 of the NHI bill establishes the Health Care Benefits Pricing Committee. Clause 27 of the NHI bill establishes the Stakeholder Advisory Committee. The functions of the SAC are not set out in the bill. These clauses As I indicated above, these clauses should have consistent terms as to define the membership, the qualification criteria across the board. So where necessary, we do know that all committees wouldn't have the same requirements, but there should be some standard clauses to give some sort of framework as to who is appointed, what periods of time, and the functioning of these committees, so there isn't a duplication and waste of resources. The next issue is the funding model. And many have commented that the funding model of the NHI fund is not clear. Clause 21A of the bill states that the National Health Insurance Fund will be funded through mandatory prepayment. Clause 57.155 states that the objectives that must be achieved in phase 2 include the establishment and operationalization of the fund as a purchaser of healthcare services through a system of mandatory prepayment. The bill defines mandatory prepayment to mean compulsory payment for health services before they are needed in accordance with income level. The definition of mandatory payment in the NHI bill does not define who will be required to make the mandatory payments. Clause 49.1 of the bill provides that the fund is entitled to money appropriated annually by Parliament in order to achieve the purpose of the Act. Clause 49.2 states that the money referred to in subsection 1 must be A, appropriate from money collected in accordance with social solidarity in respect of Roman 1, general tax revenue, including the shifting of funds from the provincial equitable share and conditional grants into the fund. Roman 2, reallocation of resources for medical schemes, tax credits paid to various medical schemes towards the funding of the national health insurance. 3, payroll tax, that is employer and employee, and 4, surcharge on income tax. And this is introduced through a money bill by the Minister of Finance and earmarked for use by the fund subject to section 57. The Department of Health in its presentation of 30th November 2023, that should have been 2022, indicated that mandatory prepayment refers to paying of health care before the person is sick. And this is compulsory according to income level. Department of Health in its presentation stated, however, there will be no opting out of paying the mandatory NHI taxes for those that are eligible to make these payments, and no prepayment through a medical scheme which will not be allowed to cover NHI benefits. The choice lies in whether a user chooses to access these services using the NHI fund or not. Therefore, access to healthcare is not restricted. Clause 48 provides for sources of funding. While a mandatory prepayment system is mentioned in the NHI bill as a source of funding for the NHI, it is not clear how this will be implemented. Clause 49, which provides a chief source of funding, refers to payroll tax and a surcharge on personal income tax. While the mandatory payment of tax will be dealt with in a money bill, the details of the payment framework are unclear in the NHI bill. The next issue that I deal with is general provisions applicable to the operation of the fund. Clause 31.1b states the fund is a Schedule 3A entity and the responsibility for governance and stewardship should lie with the board. The NHI bill established the fund as a Schedule 3A public entity, yet the powers of the minister are heavily concentrated through the structures of the fund. As a result, many submitters have raised concerns about the governance of the NHI fund. With regard to clause 31.2, clause 31.2 provides that the minister must clearly delineate in appropriate legislation the respective roles and responsibilities of the fund and the national and provincial departments, taking into consideration the Constitution, this Act, and the National Health Act, in order to prevent duplication of services and the wasting of resources, and to ensure the equitable provision of health, provision and financing of health services. Delineate means describe or portray something precisely. This clause reads as a delegation of plenary legislative powers to the minister. The minister may introduce legislation, but in terms of section 44.1 of the Constitution, The national legislative authority is vested in Parliament. Parliament may delegate secondary lawmaking functions to the minister, but it cannot delegate plenary legislative powers. This clause must be reconsidered. Clause 32(2) states that the minister may introduce proposed amendments to the National Health Act. The minister is empowered by the Constitution to introduce legislation. The clause seeks to direct in primary legislation what future primary legislation must set out. Any proposed amendment must be subjected to a parliamentary process, including public participation. A future parliament may not accept these legislative proposals. This particular provision does not need to be provided for in the law. Clause 33 states, without derogating from the Constitution or any other law, the functions of the provincial departments must be amended to comply with the purpose of the provision of the Act, subject to Section 57. This statement is open-ended and does not indicate who is required to carry out this task. The task of amending the functions of provincial departments may only be done in terms of a parliamentary process. It does not need to be provided for in the law. Clause 35 provides for the purchasing of healthcare services. Clause 35(1) provides that the NHI will purchase healthcare services in accordance with needs. The clause should clarify what needs refers to and whether it is determined on proactive or reactive basis. Clause 38 of the NHI bill establishes the Office of the Health Products Procurement. Clause does not provide for term limits, appointment procedures, and qualification requirements set out for the OHPP. Clause 39 provides for the accreditation of service providers. Many submitters have expressed concern that relatively few public facilities have achieved accreditation. There may be an impact on access to healthcare services if public facilities are not accredited. Clause 40 provides for the information platform of the fund. The wording of this clause reads, failure to disclosure the information represents a serious threat to public health. Disclosure should be amended to disclose. This is just a technical drafting issue. In paragraph 85, the NHI bill provides no information about accreditation of suppliers as required in clause 41(2). Accreditation is defined to mean to be in possession of a valid certificate of accreditation from the fund as issued in terms of Section 39. Section 39 does not indicate how suppliers will be accredited. Clause 42 provides for complaints and appeals. Clause 42(4)(a) states, if the fund has made a decision in terms of subsection 3, the fund must provide the healthcare service provider with a notice of the decision to provide the healthcare service provider with a reasonable opportunity to make representations in respect of such a decision. The provision of a notice in clause 42 should not be limited to the healthcare service provider, as the complaint may relate to other role players. In clause 55, which provides for regulations, clause 55(1)(i) and (j) states, without derogating from the powers of the minister by the Constitution, the National Health Act, or any other applicable law, the minister may, after consultation with the fund and the National Health Council contemplated in Section 22 of the National Health Act, make regulations regarding the functions and powers of the District Health Management Office and the functions and powers of a contracting unit for primary healthcare services. The District Health Management Office and the contracting unit for primary healthcare services are integral structures in the NHI fund. The functions and the powers are substantive matters and should be determined in primary legislation and not delegated to the minister. Clause 57 provides for transitional arrangements. In terms of this clause, the NHI bill must be implemented in 2 phases, with phase 1 for a period of 5 years, 2017 to 2022, and phase 2 for a period of 4 years from 2002 to 2026. The time for phase 1 has passed and the time period for phase 2 has commenced. These periods must be amended to dates after the bill is passed into law or to dates that may be determined and published in the Gazette. Chairperson, those are my comments on the NHI bill.
Thank you very much, Ms. Sue-Ann Isaac, and also your unit, and for this legal opinion which you just provided. We really appreciate this, even though you were not well and you had a bit of a throat challenge, but thank you very much for coming to deliver this presentation to us. Honorable members, we are going to take a 15-minute comfort break. We will return at 20 minutes to 12. And Ms. Isaac, we're not going to take any input from the members on this presentation now. When we return, we will go to the presentation of the state law advisors, and we will take all of the input once we had received all of the presentations, and that will be next week, and we'd have to see how that goes. Thank you once again. Honorable members, we will take that break. Honorable members, we are back. We're not going to say much. We'll go straight to the state law advisors. Advocate Johan, Advocate Theo Hercules, are you ready to present your legal opinion to the committee?
Good morning, Chairperson. Good morning, honorable members. Yes, Chair, we're ready to proceed.
Thank you very much. Please do.
Thank you. We'll share our screen with the document that we've submitted to the committee. If you could just give us a moment, please.
Pardon?
Is it possible for us to share our screen with the committee?
Yes.
Chairperson?
Yes, thank you. Do you need co-host, right? Ms. Majalamba, can you attend to it?
And Chairperson,
Clark.
sorry, Chairperson, can she raise her voice?
Yes, I'm Chairperson.
She's not audible like you are speaking, our Chairperson. So, and we would like to hear clearly what she's presenting here today. Thanks.
Thank you. Is that what your hand was raised to, Honorable Clark?
Yes, thank you, Chair. Thank you. That's
All
also
right.
what I was doing.
Ms. Johan, Advocate Johan, you've heard that. Thank you.
Thank you, Chairperson. We have been requested by the Portfolio Committee to respond to all of the legal issues that was raised by various members during the deliberations on the bill. Just as a background, Chairperson, we have attended these Portfolio Committee meetings as a result of the work that was required of us to do by National Assembly Rule 279. This rule requires that our office certifies the bill as being constitutionally sound and properly drafted in the form and style which conforms to legislative practice upon introduction of the bill by a member of the executive in Parliament. But after a bill is referred to the Parliamentary Committee, we are prepared and must be prepared to motivate our certification and our view that the bill is constitutionally sound, as well as avail ourselves to provide legal advice to the committee and to assist with the drafting of any amendments that is proposed in and by the committee. The role of the department in this process is to deal with any issue regarding government policy adopted and its implementation reflected in and implicated by the bill. Chairperson, the constitutional aspects of the bill that is before you commences with an analysis and a consideration of Section 85(2) of the Constitution, which provides that the President, together with other members of the Cabinet, is vested with the power to develop and implement national policy and to prepare and initiate the legislation. This, therefore, is the source of the constitutional source of sending the bill to Parliament for introduction. Instructive in any analysis relating to policy decisions, the Constitutional Court has held that where state policy is challenged as inconsistent with the Constitution, courts have to consider whether in formulating and implementing such policy, the state has given effect to its constitutional obligations. Our courts have also said that justification may, however, depend on policies directed to legitimate government concerns. If that be the case, the party relying on justification should place sufficient information before the court as to the policy that is being furthered, the reasons for that policy, and why it is considered reasonable in pursuit of the policy to limit a constitutional right. In the much quoted case of Bateau star fishing, the court had said that a court should thus give due weight to findings of fact and policy decisions made by those with special expertise and experience in the field. The extent to which a court should give weight to these considerations would depend upon the character of the decision itself as well as on the identity of the decision maker. A decision that required an equilibrium to be struck between a range of competing interests or considerations, and which was to be taken by a person or institution with specific expertise in that area, had to be shown respect by the courts. Chairperson and honourable members, international law also finds application in respect of the bill. We hold the view that the Republic, as a state party to a number of international instruments, is bound by the obligations that it took upon itself. The binding nature of these international agreements, in accordance with Section 231(2) of the Constitution, means that the Republic has a duty to comply with their provisions and further to domesticate these obligations into our law. The Republic, therefore, as a state party to various international and relevant instruments, is implementing a legislative measure by introducing the NHI bill in Parliament in order to give effect to its international obligation of providing healthcare services and in furtherance of Section 27 of the Constitution. Section 44(1) of the Constitution vests in Parliament the national legislative authority to pass legislation with regard to any matter, including a matter within a functional area listed in Schedule 4, which are functional areas of concurrent national and provincial legislative competence, but excluding a matter within a functional area listed in Schedule 5 to the Constitution. According to our Constitutional Court, the exercise of all legislative power is subject to two constitutional constraints. Firstly, there must be a rational connection between the legislation and the achievement of a legitimate government purpose. Secondly, the legislation must not infringe upon any of the fundamental rights entrenched in the Bill of Rights. However, our courts have confirmed that rights contained in the Bill of Rights may be limited by a law of general application in accordance with Section 36 of the Constitution. Such a limitation must be justifiable in terms of Section 36(1) of the Constitution. Turning to our jurisprudence, our courts have held that the onus of establishing the absence of a legitimate governmental purpose or of a rational relationship between the law and the purpose falls on the objector. Our courts have gone on to say that all that is required for rationality to be satisfied is the connection between the means and the purpose. Put differently, the means chosen to achieve a particular purpose must reasonably be capable of accomplishing that purpose. They need not be the best means or the only means through which the purpose may be attained. The executive has a wide discretion in selecting the means to achieve its constitutionally permissible objectives. Courts may not interfere with the means selected simply because they do not like them or because there are other more appropriate means that could have been selected. But where the decision is challenged on the ground of rationality, courts are obliged to examine the means selected to determine whether they are rationally related to the objectives sought to be achieved. What must be stressed is that the purpose of the inquiry is to determine not whether there are other means that could have been used, but whether the means selected are rationally related to the objectives sought to be achieved. And if objectively speaking, they are not, they fall short of the standard demanded by the Constitution. From the information shared with us by the department, we as the state law advisors hold the view that the provisions of the bill are rationally connected to the objective of providing sustainable and affordable universal access to quality healthcare services for all in the Republic. The combined constitutional obligations of Section 27 of the Constitution and the binding international obligations which must be given effect to are key to motivating the rationality of the bill. Moving on to a big area implicated by the bill is that of concurrent national and provincial legislative competence. Concurrent national and legislative competence means that both Parliament and provincial legislatures are equally competent and may legislate on the matters listed in Schedule 4. The Constitutional Court explained to us that a law passed by a legislature in one sphere will be inconsistent with a law passed by a legislature in another sphere when those laws cannot stand at the same time, or cannot stand together, or cannot both be obeyed at the same time. They are not inconsistent, the court went on to explain, when it is possible to obey each law without disobeying the other. Where a court finds it difficult to determine whether there is indeed a conflict in terms of section 150 of the Constitution, a court must prefer an interpretation of the legislation or the Constitution that avoids conflict over one that results in conflict. Section 146 of the Constitution, in our view, is the more apposite section from which the national government sources its authority to pass legislation which falls within the purview of Schedule 4 to the Constitution. Section 142 reads, national legislation that applies uniformly with regard to the country as a whole prevails over provincial legislation if any of the following conditions is met. The national legislation deals with a matter that cannot be regulated effectively by legislation enacted by the respective provinces individually. The national legislation deals with a matter that, to be dealt with effectively, requires uniformity across the nation, and the national legislation provides that uniformity by establishing norms and standards, frameworks, or national policies. The national legislation is necessary for the protection of the common market in respect of the mobility of goods, services, capital, and labor, and the promotion of equal opportunity or equal access to governmental services. National legislation prevails over provincial legislation if the national legislation is aimed at preventing unreasonable action by a province that is prejudicial to the economic, health, or security interests of another province or the country as a whole. In line with Section 146(2)(a), (b), and (c) of the Constitution, in our view, the bill is proposed national legislation dealing with matters that cannot be regulated effectively by legislation enacted by the respective provinces individually. In order for these matters to be dealt with effectively, they require uniformity across the Republic, and the bill provides that uniformity by establishing the national policy and framework for all spheres of government to implement and to function within. Where a conflict does indeed arise, any provincial, between the National Health Insurance Act and any provincial legislation, sections 146, 148, 149, and 150 become relevant and applicable as the circumstances require. We have earlier in the opinion described the context within which the bill must be evaluated. We discussed the powers and the functions and the role of provinces in relation to Schedule 4 to the Constitution. Just to summarize, both national and provincial governments are expressly authorized by the Constitution to enact legislation that deals with health services. Where a conflict arises, sections 146 and 148 become relevant to resolve the conflict. We point out the judgment of the Minister of Education versus Harris, where the Constitution had to decide whether the policy determined by the Minister of Education was binding on everyone. The court accepted that laws, regulations, and rules are legislative instruments, whereas policy determinations are not. As a matter of sound government, in order to bind the public, policy should normally be reflected in such legislative instruments. policy determinations cannot override, amend, or be in conflict with laws, including subordinate legislation. Otherwise, the separation between legislature and executive, excuse me, will disappear. Based on this Harris judgment, Chairperson and honorable members, it appears that legislation that empowers a minister to formulate policy, to establish frameworks, and to determine norms and standards should, in our view, determine the binding nature of that policy, frameworks, and norms and standards for provinces. Section 125 of the Constitution provides that the Premier exercises the executive authority together with the other members of the Executive Council by implementing all national legislation within the functional areas listed in Schedule 4 or 5, except where the Constitution or an Act of Parliament provides otherwise. And the Premier exercises the executive authority together with other members of the Executive Council by coordinating the functions of the provincial administration and its departments, including performing any other function assigned to the provincial executive in terms of the Constitution or an Act of Parliament. Chairperson, but for the sections referred to above, there is no other express provision that could be found vis-a-vis the role of provinces in respect of laws which may relate to health services. We argue, therefore, Chairperson, that the legislative instrument that codifies the authority to determine national policy and a framework within which governments must perform their functions is the National Health Act. We argue further that the specific roles and functions of the national and provincial governments in respect of healthcare services are determined and set out in the National Health Act. Section 2 of the National Health Act provides as its objects the desire to regulate national health and to provide uniformity in respect of health services across the nation. Section 3 of that Act provides that the minister must, within the limits of available resources, determine the policies and measures necessary to protect, promote, improve, and maintain the health and well-being of the population. Sections 21 and 25 of the National Health Act set out a detailed list of functions that must be carried out by the organ of state referred to. The envisaged amendments provided for in clause 58 of the bill, read with the schedule, would result in the addition and deletion of functions carried out by national and provincial governments. The following amendments are contained in the bill in respect of sections 21 and 25 of the National Health Act. In respect of section 21, it will now read, the Director General of the National Department of Health must, in accordance with national health policy, plan the development of public and private hospitals, other health establishments, and health agencies, control and manage the cost and financing of public health establishments and public health agencies. The Director General must also develop a national policy framework for the procurement and use of health technology, develop guidelines for the management of health districts, and assist the District Health Management Office in controlling the quality of all health services and facilities. In respect of section 25 of the National Health Act, which deals with provincial health services and general functions of provincial governments, the following is proposed to be deleted by way of amendment in the National Health Insurance Bill. The provincial departments will no longer be responsible for planning and managing the provincial health information system, plan, coordinate, and monitor health services, and must evaluate the rendering of health services, conduct or facilitate research on health and health services, plan, manage, and develop human resources for the rendering of health services, plan the development of public and private hospitals, other health establishments and health agencies, control and manage the cost and financing of public health establishment and public health agencies, and facilitate and promote the provision of comprehensive primary health services and community hospital services. We hold the view that notwithstanding Schedule 4 to the Constitution, the National Health Act is the law that determines the roles, responsibilities, and functions of the spheres of government in accordance with the national health policy determined by the Minister. The roles, responsibilities, and functions referred to above are not determined by the Constitution itself. Rather, the Constitution authorizes that both the national and provincial governments are authorized to enact legislation relating to health services. We interpret this to mean that in the context of the National Health Act, provinces may enact provincial laws to deal with health services authorized by the national framework and to give effect to the national health policy. This is evidenced by sections 3 and 25 of the National Health Act. Any amendment to the above provisions, including the introduced amendments to section 21 and 25 of the National Health Act contained in the schedule to the bill, does not, in our view, in and of itself, offend the Constitution. Moving on to the principles of cooperative government. As the legislative competencies and administration of laws relating to the NHI and health services are provided for in the bill, Chapter 3 of the Constitution becomes bearing on the actions and activities of the different spheres of government. To this extent, our Constitutional Court had said, cooperation is of particular importance in the field of concurrent lawmaking and the implementation of laws. It is desirable, where possible, to avoid conflicting legislative provisions, to determine the administrations which will implement laws that are made, and to ensure that adequate provision is made, therefore, in the budgets of the different governments. The constitutional principle of cooperative government must be complied with in the exercise of concurrent national and provincial legislative competence and lawmaking regarding health services. It is our view that by introducing the bill in Parliament, the national government is not encroaching on the geographical, functional, or institutional integrity of the provinces and is not usurping their functions. The substantive contents of the bill are an important consideration when applying the constitutional principles outlined above, and when testing the provisions of the bill, excuse me, for purposes of legality and desirability within the context described above. We hold the view that the National Executive, in accordance with Section 85(2) of the Constitution, is authorized to develop and implement national policy. This constitutional authorization includes an amendment or change of policy motivated by imperatives that may necessitate such amendment or change. This, in and of itself, is not constitutionally unsound, provided that the amendments or change of policy is demonstrated to meet the relevant constitutional requirements of rationality, reasonableness, and non-arbitrariness. The introduction, therefore, of a single mechanism to secure equitable, quality healthcare for the entire population of the Republic is not, in our view, automatically an infringement of Section 27 of the Constitution. Chairperson, moving on to Clause 3 of the bill, we wish to point out its significance, which provides that the envisaged National Health Insurance Act does not in any way amend, change, or affect the funding and functions of any organs of state in respect of healthcare services until legislation contemplated in Section 77 and 214 read with Section 227 of the Constitution and any other relevant legislation have been enacted or amended. Clause 3, subclause 4 of the bill is an important provision relating to the ultimate implementation of the bill when enacted. The effect of the clause contained in the text as an express substantive provision will be that the laws required to be amended and new laws required to be enacted must be completed before the National Health Insurance Framework Law is put into operation in its entirety. But for preparatory work that is authorized under the NHI, until such time as the process outlined in Clause 3, Sub 4 is complete, the status quo as reflected in the National Health Act and other applicable and relevant laws remain intact. We have had many discussions relating to Chapter 2 of the bill. This chapter provides for access to healthcare services, and it expressly makes reference to South African citizens, refugees, permanent residents, children, and inmates. We have been requested to consider the provisions of the laws dealing with specifically asylum seekers and to advise on the legality of the provisions of Chapter 2 insofar as it relates to foreign individuals. It must be noted that Chapter 2 limits the right of access to healthcare in respect of an asylum seeker and an illegal foreigner. These categories of persons, in terms of Clause 4, Subclause 2 of the bill, are only entitled to emergency medical services and service for notifiable conditions of public health concern. Other foreign persons visiting the Republic, not in possession of a travel insurance contract or policy, may access only emergency medical services and services for notifiable conditions of public health concern. Section 27 of the Refugees Act affords full legal protection to refugees in the form of the rights set out in Chapter 2 of the Constitution, the Bill of Rights. This protection includes the right to healthcare services in addition to emergency medical services, in line with Section 27(1)(a) of the Constitution. We are of the opinion that Clause 4, 1(c) is in line with the Refugees Act insofar as it relates to accessing health services. That is, it places a refugee in the same position as a citizen of the Republic. We are of the view that the limitation of the rights of foreign individuals to the extent provided for in the bill, based on references made to available resources in Section 27(2) of the Constitution, and meets the requirements of the limitations test provided for in Section 36 and is constitutionally sound. We've set out to find jurisprudence that relates to the rights of foreign individuals. As you're aware, Chairperson, many of our court's judgments responds to applications made by individuals that relates to delays in deciding applications and so on. So it's really in the area of home affairs that these judgments relate to. We have, however, found one or two judgments that are pertinent to and relevant to the consideration of the clauses contained in the NHI. One of the most important ones that we have found is the matter of the Union of Refugee Women case, where it dealt with the exclusions contained in the Private Security Industry Regulation Act. In that act, a provision was challenged on the basis that the provision did not give effect to the Equality Clause, Section 9 of the Constitution, insofar as it provided that only citizens and permanent residents of the Republic were eligible to be registered as private security service providers under that act. The court, in its final analysis, held that the discrimination between citizens and permanent residents on the one hand, and all other foreigners, including refugees on the other hand, was not unfair in the circumstances and did not breach the equality right threshold. The court found that the scheme that was adopted in the CEDA Act was not a blanket ban on employment in general, but is narrowly tailored to the purpose of screening entrance to the security industry. It held that the scheme is flexible and has the capacity to let in any foreigner when it is appropriate and to avoid hardship against any foreigner. It permits blanket exemption of categories of work within the industry and permits departure from the strict requirements of Section 23 of that Act on good cause shown. The Constitutional Court stated that the discrimination is a legitimate legislative choice on a highly prized public interest, which is safety and security in a country where security workers in that industry exceed the police and the army in number. So from that, Chairperson, we are of the view that the test developed in the matter of Harkson versus Lane to determine whether a provision differentiates between people or categories of people, and if so, whether that differentiation bears a rational connection to a legitimate government purpose, including the test to determine unfair discrimination in the Union of Refugee Women case, may be relevant to the determination whether the categorization of persons, that is, South African citizens, permanent residents, inmates, asylum seekers, refugees, and illegal foreigners listed in Chapter 2 of our bill, who are eligible for access to healthcare services, is constitutionally sound. Thus, an argument can be raised that the same principles enunciated by the Constitutional Court in those judgments may be applied to the justification of the categorization of persons mentioned in Chapter 2 of our bill, who are eligible to access healthcare services as envisaged and to the extent provided for in the bill, taking into account the available resources as contemplated in Section 27(2) of the Constitution. Chairperson, in committee meetings, your committee members and yourself have engaged in deliberations and discussion relating to children, and we've attempted to respond to the legal issues and to the questions raised during those deliberations. So Chapter 2 of the bill also provides for the registration of users with a fund and the rights of these users. Clause 4, subclause 3, stipulates that all children, including children of asylum seekers and illegal foreigners, are entitled to basic healthcare services as provided for in Section 28(1)(c) of the Constitution. There, the provisions are identical. Section 28(1)(c) in turn reads that every child has the right to basic healthcare services and social services, amongst others. We interpret basic healthcare services as distinguishable from and which amount to more services than emergency medical services, which is defined in the bill as services provided by any private or public entity, dedicated, staffed, and equipped to offer pre-hospital acute medical treatment and transport for the ill or injured. Clause 5, subclause 2 requires that a person eligible to receive healthcare services in accordance with the bill must register his or her child as a user with the fund, but goes on to provide that a child born to a user is regarded as having been registered as a user automatically at birth. There may be children who fall outside of the purview of that provision. The bill therefore continues to make provision for other categories of children who may require health services, including children aged between 12 and 18 and children in child-headed households. As far as we are able to ascertain, and in response to a very specific question asked by one of the members, no further amendment to the Children's Act is in our view required. During the deliberations on the bill, Chairperson and honorable members, members of the committee correctly, in our view, raised a concern relating to the correctness of clause 7(2)(f)(1), which provides that the minister must by regulation designate central hospitals as national government components in accordance with section 7 sub 5 of the Public Service Act. To correct the defect, Chairperson, and with your indulgence, we would like to propose that the committee considers a provision for inclusion in an A list, which will read as follows. The minister must request the Minister of Public Service and Administration to consider and assist in the establishment of central hospitals as national government components in accordance with section 7 sub 5 of the Public Service Act. And it goes on to read, where central hospitals are not established as national government components, the minister must establish or designate central hospitals as an organ of state in an appropriate form. Chapter 3 of the bill provides for the establishment of the fund as a national public entity as contemplated in the Public Finance Management Act. The chapter also contains a list of powers and functions of the fund, which include the taking of all steps reasonably necessary to obtain universal health coverage. This we accept to be that all people and communities can use the promotive, preventive, curative, rehabilitative, and palliative health services they need of sufficient quality to be effective, while also ensuring that the use of these services do not expose the user to financial hardship. There is no provision contained in the Competition Act which elevates that act to enjoy a more superior status than an NHI law if enacted. In light of this, it may be concluded, as we do, Chairperson, that exemptions from the application of the Competition Act is legally permissible and authorized when expressly provided for or authorized in law. In addition, Section 3, subsection 1, capital A of the Competition Act provides as follows. Insofar as this act applies to an industry or sector of an industry that is subject to the jurisdiction of another regulatory authority, which authority has jurisdiction in respect of conduct regulated in terms of Chapter 2 or Chapter 3 of the Competition Act. The Competition Act must be construed as establishing concurrent jurisdiction in respect of that conduct. The manner in which the concurrent jurisdiction is exercised in terms of the Competition Act and any other public regulation must be managed to the extent possible in accordance with any applicable agreement concluded in terms of sections 21 and 82 of the Competition Act. We have interpreted section 3 of the Competition Act when applied to the National Health Insurance Bill to mean that the NHI fund as a regulatory authority enjoys concurrent jurisdiction with the Competition Commission to regulate the conduct referred to and contemplated in the Competition Act. Further, Chapter 2 of that Act defines and regulates practices which has the effect of substantially preventing or lessening competition in a market. However, the Competition Act provides that firms, as defined in the Act, may apply to the Competition Commission to be exempted from the application of Chapter 2. It stands to reason, therefore, Chairperson, that the legislature intended exemptions of certain bodies and certain market activity from the application of the Competition Act, and to grant certain regulatory bodies, other than the Competition Commission, the requisite authority and jurisdiction to regulate conduct within its industry or sector. Clause 9 of the bill establishes the NHI fund as a Schedule 3 capital A autonomous entity. The bill also provides that the board of the NHI fund carries out its functions in accordance with the PFMA. relevant to the discussions surrounding the board of the NHI and their functions, sections 50 and sections 51 of the PFMA are of utmost importance. These sections detail specific duties and obligations applicable to the board of the NHI fund. These, by way of example, we refer in section 50 to the duty of an accounting authority, and it stipulates that the accounting authority for a public entity must act with fidelity, honesty, integrity, and in the best interests of the public entity in managing the financial affairs of the public entity. Seek within the sphere of influence of that accounting authority to prevent any prejudice to the financial interests of the state. A member of an accounting authority may not use the position or privileges of or confidential information obtained as accounting authority or a member of an accounting authority for personal gain or to improperly benefit other persons. Section 51 of the PFMA carries further duties and obligations that would borne on the members of the fund. The statutory duties and obligations contained in the PFMA, in our view, Chairperson, responds to the concerns raised in your committee. The Act further contemplates the degree of interaction between the board and the relevant minister. Finally, Section 3, subsection 3 provides that in the event of a conflict between the PFMA and any other legislation, including the NHI, should it be enacted, the PFMA will prevail. This, in the area of financial management and controls, would subordinate an NHI Act to the PFMA. We are satisfied, therefore, that the provisions of the bill, especially those relating to the role and functions of the fund and their accountability, are aligned with the PFMA and the Competition Act and are constitutionally sound. Chapter 7, Chairperson, makes provision for the appointment by the Minister after consultation with the board of a Benefits Advisory Committee, a Healthcare Benefits Pricing Committee, and a Stakeholder Advisory Committee. The chapter also provides for the disclosure of interest by members of these committees, their composition, their functions and working procedures, their remuneration and vacation of office by members of the committee. Two types of committees are contemplated in the bill. Chapter 6 provides for the appointment of committees by the board of the NHI fund. These committees contemplated in the bill we submit are the internal and often technical committees commonly provided for in legislation. These committees are regarded as mechanisms to assist the board with carrying out its responsibilities, its governance and management in the most efficient and effective manner. There are examples of these various committees in many other laws. Some ones that are relevant to us would be Section 10 of the Health Professions Act, Section 10 of the Allied Health Professions Act. Chapter 7, in comparison with Chapter 6, contemplates and instructs the minister to establish certain advisory committees. Specifically, clauses 25 and 26 provide that a benefits advisory committee and a healthcare benefits pricing committee must be established. These advisory committees deal with seemingly the most important aspect of the national health insurance, that is, the benefits offered by the NHI to its users and the prices of health goods and services. The subject matter intended to be dealt with by these committees may be regarded as the aspects of the NHI that generates the widest public interest. Given the importance of the work of these committees, the conventional power of a minister to establish a panel of experts to investigate and make recommendations to him or her has now been expressly provided for in the bill, to the extent that the bill compels the minister to establish these committees of experts to consider which benefits will be afforded to users, as well as the pricing of health goods and services. The work of these statutory advisory committees is intended to inform decisions taken. Chairperson, Chapter 7 must be read with Clause 57 of the Bill to inform the purpose of interpretation and true meaning of the provisions. The substance of Chapter 7 and Clause 57 are contained in the NHI policy instruments, which reads, in Phase 1, the Minister may establish the following interim committees to advise him or her on the implementation of the NHI. Most important in our view of these is that the Ministerial Advisory Committee on Healthcare Benefits for National Health Insurance, which must be a precursor to the Benefits Advisory Committee and which must advise the Minister on a process of priority setting to inform the decision-making processes of the fund to determine the benefits to be covered. We note and acknowledge that there are various ways of drafting committee provisions, both in Chapter 6 and Chapter 7, and the preferences of the Portfolio Committee may be given way to by way of an A-list if more detailed provisions or alternate provisions are desired. Notwithstanding, Chairperson and honourable members, we hold the view that the current clauses reflected in these chapters are not legally offensive. Excuse me. We have also been asked to consider the possibility of a conflict of interest arising as a result of the operation of the provisions of the NHI Bill. Specifically, the question was posed in relation to the role of the Minister in the leadership and the operations of the NHI. And we've looked within our South African jurisprudence to find what legal principles and what legal authority exists and which ones are instructive and bearing on us. We were unable to find anything in South African law, but we looked to foreign law and found Canadian and English judgments that may be applicable and instructive to us in the area of conflict of interest. And the definition of conflict of interest, according to these foreign jurisprudence, is said to refer to a conflict between interest and duty or duty and duty. The duty that is referred to is defined as a duty to advance the beneficiary's interest or as a duty to act with the proper motive or in a negative manner as a duty to abstain from acting self-interestedly. In order for a potential conflict of interest to exist, there must be a reasonable possibility of such conflict, not merely an appearance. In the United Kingdom, its courts have said that the cases establish that the potential conflict must be a reasonable apprehension of a potential conflict, not a mere theoretical possibility. In Canada, their courts have said, the question to ask is whether, given all the surrounding circumstances, one party could reasonably have expected that the other party would act in the former's best interest with respect to the subject matter at issue. Discretion, influence, vulnerability, and trust were mentioned as non-exhaustive example of evidential factors to be considered in making a determination as to whether or not conflict of interest is implicated and arose. From those judgments, overseas and foreign judgments, we hold the view that the minister holds a duty of loyalty to act and to exercise his or her powers in the best interests of the users of and those regulated by the NHI. We further opine that we are unable to find any provision in the bill that creates a conflict of interest or a reasonable possibility of a conflict of interest. Moving on to medical schemes, Chairperson and honourable members, medical schemes registered in terms of the Medical Schemes Act or any other voluntary private health insurance scheme will provide only complementary cover for healthcare service benefits that are not purchased by the fund on behalf of users. Clause 57 of the bill, which is the transitional arrangements, provides that one of the objectives of phase 1 in the implementation of the NHI law is the initiation of legislative reforms required to introduce the NHI. The Medical Schemes Act is expressly referred to as one of those legislative reforms required. It is therefore envisaged that the necessary amendments to the Medical Schemes Act must be enacted to enable the implementation of the NHI. Clause 39 of the bill provides for the accreditation of healthcare service providers and health establishment by the fund. There are a list of criteria that must be met for accreditation in clause 39 sub 2. It has been raised by members of the Portfolio Committee that the provisions of the bill divests persons of their constitutional right to choose their trade, occupation, or profession freely. We offer that Section 22 consists of two components. The first is the award or the granting of the right to choose a trade, occupation, or profession freely. And secondly, is the authorization contained in the Constitution itself to regulate the practice of a trade, occupation, or profession by law. We hold the view that the provisions of the bill, insofar as it provides for the accreditation of healthcare service providers and health establishment, is a mechanism or scheme employed to regulate the practice of a trade, occupation, or profession, and it's a means by which the objectives of access to and quality of healthcare services finds expression. Important in the valuation of the meaning of Section 26 of the Constitution and related to an evaluation of Section 2 in this context, Subramani versus the Minister of Health, an old 1997 judgment, still finds application to our consideration today, Chairperson. The court said that the Constitution is forward-looking and guarantees to every citizen fundamental rights in such a manner that the ordinary person in the street who is unaware of these guarantees immediately claims them without further ado, and assumes that every right so guaranteed is available to him or her on demand. The court said that some rights in the Constitution are the ideal and something to be strived for. They amount to a promise, in some cases, and an indication of what a democratic society aiming to salvage lost dignity, freedom, and equality should embark upon. They are values which the Constitution seeks to provide, nurture, and protect for a future South Africa. The court said, however, the guarantees of the Constitution are not absolute and may be limited in one way or another. In some instances, the Constitution states in so many words that the state must take reasonable, legislative, and other measures within its available resources to achieve the progressive realization of each of these rights. In its language, the Constitution accepts that it cannot solve all of our society's woes overnight, but must go on trying to resolve these problems. One of the limiting factors to the attainment of the Constitution's guarantees is that of limited or scarce resources. In the present case, the limited hemodialysis facilities, inclusive of hemodialysis machines, beds, and trained staff, constitute the limited or scarce facilities. In the Treatment Action Campaign judgment, the Constitutional Court said, we therefore conclude that Section 27(1) of the Constitution does not give rise to a self-standing and independent positive right enforceable irrespective of the considerations mentioned in Section 27(2). sections 27(1), section 27 sub 1, and section 27 sub 2 must be read together as defining the scope of the positive rights that everyone has and the corresponding obligations on the state to respect, protect, promote, and fulfill such rights. The rights conferred by section 26(1) and 27(1) are to have access to the services that the state is obliged to provide in terms of section 26(2) and 27(2). In respect of section, or coming back to section 22 of the Constitution, the court, our constitutional court had said, legislation that regulates practice, here I'm referring specifically to the practice of a trade, occupation, or profession. Legislation that regulates practice will pass constitutional muster if A, it is rationally related to the achievement of a legitimate government purpose, and B, it does not infringe any of the rights in the Bill of Rights. What the Constitution therefore requires is that the power to regulate the practice of a profession be exercised in an objectively rational manner. As long as the regulation of the practice, viewed objectively, is rationally related to the legitimate government purpose, a court cannot interfere simply because it disagrees with or considers the legislation to be inappropriate. Where the regulation of a practice, viewed objectively, is likely to impact negatively on the choice of a profession, such regulation will limit the right to freely choose a profession guaranteed by section 22 and must therefore meet the test under section 36(1). Similarly, where the regulation of practice, though
can you just scroll? I think you've scrolled too far. Whoever's scrolling on your behalf, I was still reading. I think you're 2 pages ahead now.
Yes, Chairperson. Where the regulation of a practice, viewed objectively, is likely to impact negatively on the choice of a profession, such regulation will limit the right freely to choose a profession guaranteed by section 22 and must therefore meet the test under section 36 subsection 1. Similarly, where the regulation of practice, though falling within the purview of section 22, but limits any of the rights in the Bill of Rights, it must meet the section 31 standard. From all of the judgments that we have found that is applicable to a section 22 analysis or a section 22 test for the NHI purpose, we have determined that in order to decide whether or not the regulation of a practice, trade, occupation, or profession falls within the purview of 22, the following applies. If the said section or provision in the NHI, viewed objectively, is likely to have a negative impact on the choice of a profession, in other words, the right contained in the first component of section 22, the regulation will indeed limit that right, and the limitation will only be saved if once section 36 of the Constitution is applied, it is determined that it meets the requirements of section 36. If there is a rational connection between the regulation of the practice and a legitimate government purpose, and the regulation does not infringe any of the rights, such regulation will pass constitutional muster. And then thirdly, if there is a rational connection between the regulation of the practice and a legitimate government purpose, and in addition, there is an infringement on any of the rights of the Bill of Rights, such regulation will have to be tested against section 36 of the Constitution. What is clear from the exposition in the previous paragraphs, Chairperson, is that in the application of section 22 of the Constitution, there is a tension between the power to regulate a profession provided for in the second component of section 22 and the right to choose a profession, which is contemplated in the first component. If regulating the profession limits the right freely to choose an occupation, the limitation must be measured against Section 36 of the Constitution. In this regard, Chido mentions the following. The difficulty of drawing a line between the regulation of choice and regulating of practice is an unavoidable one. What the difficulty does highlight is the need to scrutinize the particular restrictive provision to determine if there is a rational basis for its regulatory features. If there is, and it has no demonstrable direct or indirect impact on the effective choice on economic activity, that should be the end of the inquiry. If there is a rational basis for the restriction, but it also restricts the effective choice of participating in an economic occupation, the provision's legitimate regulatory characteristics will not be the end of the debate. Excuse me. The curtailment of the right of choice should still be subject to all the requirements of Section 36. Thus, for us, Chairperson, as the state law advisors, the consideration of the reasonableness of a limitation on a constitutional right involves the weighing up of competing values. Ultimately, it must be decided whether there is sufficient proportionality between the infringement and the benefits it seeks to achieve. Our analysis thus involves the following. Do the provisions of the bill affect one's right to choose freely a profession, or do the provisions amount to the regulation of the practice of the profession? Is there a rational connection between the freedom to choose or regulation of the profession and, on the other hand, a legitimate government purpose? C, are any rights granted in the Bill of Rights infringed? And D, if a limitation does indeed occur, does the limitation meet the standards of Section 36 of the Constitution? For us, the stated governmental purpose for the introduction and enactment of this bill is to achieve universal access to quality healthcare services in the Republic. We hold the view that the provisions of the bill, especially Clause 39 thereof, is a mechanism employed to ensure all eligible users of the NHI are granted access to healthcare services, and that healthcare services provided are of an appropriate quality. In our view, Clause 39 is not novel to South African law. Examples abound of laws that set out requirements that must be met before registration as or to practice as professionals. The mechanism or scheme, therefore, in our view, is rationally connected to a legitimate government purpose. The objectives of access and quality further persuades that the provisions of the bill purports to regulate the practice of the profession rather than one's right to choose a profession freely. From the above then, Chairperson and honorable members, we are of the view that the bill lawfully regulates the practice of a trade, occupation, and profession. If, however, a court indeed finds that the right to freely choose a profession is indeed infringed by the bill, we hold the view that the limitation would successfully fall within the parameters of Section 36 of the Constitution, as the bill is a law of general application, and the limitation of Section 22 is reasonable and justifiable in an open and democratic society. Chapter 10 makes provision for the sources of income of the bill. The South African Revenue Service will undertake all revenue collection related to the fund, including the collection of any supplementary health taxes or levies, and so on. Chapter 10 provides for the chief source of income of the fund and the auditing of the books of the fund by the Auditor General. The provisions contained in the bill, which relate to the financing of the fund, follow precedents which have been employed previously in our law. There are examples which are available for consideration by the committee As a first example, we have the Road Accident Fund Act. We have, as a second example, the Skills Development Act and the Complementary Skills Development Levies Act. A further example is the Unemployment Insurance Contributions Act. We are satisfied that the provisions in the bill directed at the funding of the NHI are administrative provisions which will at a later stage require the initiation and introduction of a money bill by the Minister of Finance. It is important to note that the initiation and introduction of legislation envisaged in Chapter 10 is in line with Clause 3, Subclause 4 of the bill, which provides that the Act does not in any way amend, change, or affect the funding and functions of any organs of state in respect of healthcare services until legislation contemplated in Section 77 and 214, read with Section 227 of the Constitution, and any other relevant legislation have been enacted or amended. The transitional arrangements in respect of the bill contain provisions for the periodic phasing in of the National Health Insurance Policy and Act. In terms of phase 1, amongst other things, the continuation with the implementation of health system strengthening initiatives, including alignment of human resources with that which may be required by users of the fund, will take place. During phase 1, various ministerial committees must be established to assist in the phased implementation of the National Health Insurance. There will be migration of central hospitals that are funded, governed, and managed nationally as semi-autonomous entities, and the initiation of legislative reforms in order to enable the full implementation of the National Health Insurance. This entails amendment of various pieces of legislation, many of which are identified in Clause 57 of the bill. In terms of phase 2, there will be a continuation of health system strengthening initiatives on an ongoing basis, the mobilization of additional resources where necessary, and the selective contracting of healthcare services from private providers. The objectives that must be achieved in phase 2 include the establishment and operationalization of the fund as a purchaser of healthcare services through a system of mandatory prepayment. The first tranche of repeals and amendments to relevant laws are reflected in the schedule to the bill. Before the bill was introduced into Parliament, the bill was approved by Cabinet. Apart from the legislation that the Minister of Health is responsible for, Cabinet members have been consulted in respect of the legislation they are responsible for, as listed in the schedules. Specifically, the Minister of Employment and Labour as responsible for compensation of occupational injuries and diseases, Minister of Transport for the Road Accident Fund, and so on. In terms of the wording of Clause 58, the schedule to the bill forms part of the entire bill. Therefore, the Portfolio Committee may consider, deliberate, and adopt amendments to any of the legislation listed in the schedule to the bill in the same manner as in the case of other parts of the bill. We have specifically responded to a query whether or not consultation between this Portfolio Committee and other Portfolio Committees are required. We have specifically been asked to respond to the question whether or not other laws may be amended by the NHI bill. In doing so, Chairperson, we have also considered the rules of the National Assembly. And in terms of Rule 286 of the National Assembly, a committee must give interested persons, the public and institutions, an opportunity to comment on a bill, ensuring public involvement and participation. This is in line and gives effect to Section 59, subsection 1, paragraph A of the Constitution. The above mentioned rules also illustrate the extent of compliance by the National Assembly with sections 57 and 59 of the Constitution. The committee's attention is drawn to the Constitutional Court judgments in the Land Access Movement of South Africa, the MOSA judgments, where the Amendment Act, the Restitution of Land Rights Amendment Act was challenged on numerous grounds, including that the National Council of Provinces public participation procedure in approving the Amendment Act was invalid. The court considered that the applicable constitutional sections and set out to determine whether or not this challenge ought to be successful. And the court said that
You sent me a message to say shout when you're ready. I said I'm ready.
relying on Newclick's judgment, the court, our constitutional court, had said the forms of facilitating an appropriate degree of participation in the lawmaking process are indeed capable of infinite variation. What matters is that at the end of the day, a reasonable opportunity is offered to members of the public and all interested parties to know about the issues and to have an adequate say. The court said in the MOSA, the reasonableness of Parliament's conduct depend on the peculiar circumstances and facts in issue. When determining the question whether Parliament's conduct was reasonable, some deference should be paid to what Parliament considered appropriate in the circumstances, as the power to determine how participation in the legislative process will be facilitated rests upon Parliament. The court must have regard to issues like time constraints and potential expense. It must also be alive to the importance of the legislation in question and its impact on the public. Having said this, Chairperson, we hold the view that public participation in respect of both the substantive provisions of the bill as well as the items of the schedule to the bill have been considered by members of the public when the opportunity was granted by Parliament. We thus hold the view that further public hearings on specifically the items of the schedule may not be required. As to further consultation with the ministers who administers the acts listed in the schedule, or conference with the committees of Parliament, the desirability of consultation is at the disposal and is the decision of the Portfolio Committee of Health. But insofar that the authority to amend other acts, non-health acts, is questioned, we hold the view, Chairperson, that it is authorized and it is legally sound. In conclusion, Chairperson, we've considered the provisions of the bill to ensure that it is aligned with the provisions of the Constitution, with case law that we've researched, and with other relevant legislation that we've considered. We are satisfied that the provisions of the bill do not infringe any of the fundamental rights contained in the bill and in an unlawful way. We are of the opinion that there is a rational connection between the proposed legislation and the scheme which it seeks to adopt and the achievement of a legitimate government purpose. And that is to establish the fund in the Republic in order to achieve sustainable and affordable universal access to quality healthcare services by serving as a single purchaser and single payer of healthcare services, and ensure the equitable and fair distribution and use of healthcare services. The policy adopted and legislative instrument introduced purports to ensure the sustainability of funding for healthcare services within the Republic and to enable equity and efficiency in funding by the pooling of funds and strategic purchasing of healthcare services, medicines, health goods, and health-related products from accredited and contracted healthcare service providers. We are therefore satisfied, Chairperson and honourable members, that Parliament, in passing the proposed legislation, would not be acting capriciously and arbitrarily in violation of the rule of law, thereby rendering such legislation inconsistent with the Constitution. Thank you, Chairperson.
Thank you very much, Advocate Joa. Let me take this opportunity to thank you and Advocate Theo Hercules. I see that both of you had co-signed this document and also for coming to present it. Honourable members, we have received both presentations. We are now at 12:55 and it's actually worked out very well because our allocated time was to 1300 hours. I want to again thank the two legal teams, the Legal Services of Parliament and the legal team of the State Law Advisors for wonderful work they've done to provide us with a legal opinion. It is up to us now to have that further engagement next week, which will be discussion of what has been presented to us. We have nothing else that we will be attending today. To honourable members, and just to remind you that next week's portfolio committee will be a physical meeting. You need to look at the challenges with flights so that you book your flights early. Next week, Wednesday, 9:30. Thank you very much. This meeting is adjourned.
Thank you, Chair.
Thank you, Chair.
Thank you, Chair.